Hello, hello, everyone. Welcome to this week's brunch. We are so excited to be soon joined by Mr. Douglas Levitt. Let us know where you're signing in from. Melissa, thanks for letting us know. Welcome, welcome. I got Simos coming on very soon. He's just connecting. Knowing him, he's getting a massive brunch ready for himself or his family. Good morning. As always, we have Tyler, Mr. Tyler Tai, aka Air Traffic Controller, Director of Real Estate Concierge Services. In the background, we have Mr. Bobby Puim, our boy, Director of Operations for REC Canada. There's Simos. There he is. What's going on?
Good morning, my boy. Good morning, REC Insiders. I hope everyone is safe and enjoying their Saturday morning. I'm personally having some technical difficulties. I just have to log in from the iPad. The old Lenovo is acting up. So, apologies to everyone, but I've been trying for some time now, but here we are.
We're here. We're on time. We're going to have Mr. Douglas Levitt joining us. We'll talk about who he is and what he does. We're going to be bringing him on probably in about 4 to 5 minutes. So if you have any questions around the landlord-tenant board, questions about like if you're a landlord or if you know of a landlord, make sure to get those questions in the Q&A section. Tyler and Bobby are monitoring that. But to you, Simos, my man, how was your week, brother?
It was a very busy week. We're working on a lot of fun stuff that we're going to be engaging a lot of people over the next little while. So I'll drop a little hint, nudge. We're working on a very exciting JV.
Simos, are you dangling carrots already?
Dangling. No, it's very exciting. This is one that we're going to be very involved in. So I personally, I'm not just, this week has been above and beyond clients. We're looking at a major play within our own portfolio. So due diligence has been key. We're engaging a lot of our strategic partners from Carson, Dunlop inspections, dangerous. There's just so much on the go. And a lot of our clients are making move. I was speaking to the boys from AKA Media. They're looking at a major acquisition to relocate their head offices. There's just a lot on the go right now. A lot on the go, both on the commercial multiplex side, from the new construction launch sides to our resale division. It's been a crazy week. Thank goodness I have Bobby on my side that's been handling the team operations specifically, because I was looking at the number. We're actually at 38 realtors, and this year has been huge for our growth. Above and beyond everything else that we do, we've been servicing more clients than ever. So as far as COVID's concerned, our clients are going bananas.
Yeah, I think a lot of it has to do with that. People, I mean, even if the borders are closed for a bit and we're wearing masks, we need a place to live, right? We'll be wearing masks. We could possibly be wearing masks for a very long time, but the fact of that you need a place to live, it's why, one of the biggest reasons we got into real estate 15 years ago. From a business perspective, it's something that everyone needs. And we're so blessed to be doing this in the greater Toronto area. Welcome to everybody that's coming on our live here on Zoom, as well as YouTube and Facebook. Welcome. If you're new to our family, welcome to the REC family. I'm one of the co-founders, Jazz Takhar. I'm joined with the other co-founder here, Simeon, Simos, Papailias. And in the background, as I mentioned, we have Tyler Tai Walburn, who's Director of Real Estate Concierge Services, and Director of Operations, Mr. Bobby Puim. We want to
Jazz, I like how we have like our alternate names, but they're really our names. So it's like Simeon, Simos, Papailias.
Well, I mean, people ask me, is Jazz your real name? No, this is Jaspinder. It's short for Jazz. We made it a little easier for everyone. Good morning, Elaine. Good morning. Let us know where you're signing on from. We're going to be bringing on our guests very, very shortly. I just wanted to, again, if you're new to the family, something that a lot of our insiders have taken advantage of, and big shout out to all the attendees to 2 weeks ago, the brunch that we did for getting involved in our real estate action plan. It really is one of the, it's how we get started with our clients. It's 20 minutes. Obviously, nowadays it's done virtually, where we get a better idea of what you're trying to accomplish long-term within the real estate world. We'll show you how we might be able to help, because we can't help everyone. And all you got to do is send a quick email to info@reccanada.com. Do not send it directly to Jazz, because I probably won't reply back in a timely manner. It's why we have the crew that is with us, and Tyler will man that. But Bobby, can you please now bring in our guest, Mr. Douglas Levitt? Let's bring him on. He's been practicing law since 1999, so over 20 years now. Look at that handsome face. Welcome, Mr. Douglas. How you doing?
How are you guys doing this morning?
Fantastic.
Good morning, and welcome, Doug. How are you, pal?
We're doing good. We're doing good over here.
I also want to give a shout out to your team, Douglas, and in particular, Rachel, who heads the paralegal department when it comes to all things landlord and tenant. She couldn't join us today. Big shout out to Rachel. I know she's taking care of her beautiful son, Mason, and you're probably watching. You better be watching. And so welcome again, Douglas. You, as I mentioned in the intro, you've been practicing law for a very long time, and focusing your team and your staff focus a lot around the landlord-tenant board. So, I just wanted to quickly get it started, as we're going to have a conversation. So Simos, obviously, pipe in. Is the board open now? Like, what's going on? Is the landlord-tenant board open now?
The board is open and running. It's been running since August 4th. Eviction applications for landlords are getting heard. Evictions are being carried out. Tenant applications have always been getting heard. And in fact, all of the applications, all of the hearings are done like this, in a video conferencing software. This is not, and that's no different from any other courtroom. I mean, I do most of my litigation now online, exactly like this. Sometimes you'll have 90, 100 people in a courtroom, all on Zoom with a million different squares and images. It's a new world. But things are happening. Now, things are happening very slow, because there's a massive backlog, and it may feel like landlords, those particularly that filed applications before November 2020, that things aren't happening, but it's just going really, really, really slow. And that's the problem.
Pre-COVID, Douglas, and this is more for me from a selfish perspective. I wanted to know, how long would a dispute generally take, and then I want to follow that up with, when you spoke about the log now and the backlog, how long is it taking now? And I know it's hard to say exactly, but kind of off the top of your head.
So in December 2019, okay, because I'm familiar with some of the statistics out there. In December 2019, which is really the last time I looked, or the last time there were any real good statistics about turnaround time, you were looking at about an 8-week average turnaround on a rental arrears application, okay? 8 weeks. Now that is double the intended service standard that the LTB themselves promoted. They would say that we turn these things around in just a few weeks, a couple of weeks, but it was more than double. It was about 8 weeks. Those are rental arrears applications. Now the conduct applications, where tenants engage in bad behavior, that took longer. Okay. Now that's an average, and the average obviously is impacted mostly by Toronto, where most of the hearings are heard. But Toronto always had the biggest backlog. The other thing that was happening in December 2019 was that there were no adjudicators. I think the number, if memory serves me correct, was that there were about 50 or 45 active adjudicators hearing cases. The LTB, I think when they're running at full steam, I think they're at about 80. And so they really had at the time half the amount of adjudicators to hear, a ton load of cases. Mm-hmm. So things weren't getting pushed through. And, there are reasons for that. Some political, people weren't getting hired. I think, I'm not speaking for Premier Ford, but you know how he likes to sort of overhaul all systems to make them, from his perspective, more cost efficient. There may be some of that going on. Now that's changed. So now there's, I believe, close to 80 adjudicators now working and hearing cases and working through the backlog. So things are moving slow, but quicker than they would. It's very good.
So just to that, like even you're saying 8 weeks. We've never had an issue rise and fall within that 8-week time frame that is even double what you're saying. All our experience have been 3 to 6 months at the very least.
Yeah, if you're lucky.
Which is clearly unacceptable. So our clients are investors like us, and we have had no shortage of anecdotes to talk about. Yes, we have a better track record than most because this is our business. So it's a little bit more difficult for us to get duped by a professional tenant. But rest assured, we have been, and we will again. So it's not a matter of when. It's not a matter of if it's going to happen. It's a matter of when it's going to happen and how frequent, depending on how many doors you have. But from your perspective, Doug, what would you say, given the current backlog and environment? Does this warrant the landlords that, and we have hundreds that are our clients, investors, and their landlords? Do they even attempt filling out a form right now, given that if you make a mistake, you got to start from scratch? Or is this the time to make sure that you have professional representation, make no mistakes, you have kind of one shot at getting in that 8-week window? What's your advice just off the bat?
I'll tell you a couple of things there. What I deal with a lot of professional tenants, so I'm going to circle back to your question, and I have been for decades. And one of the things that the quote unquote professional tenants will do, if we're talking about the same type, is not pay their rent, get to the landlord and tenant board, lose the case there, maybe review it and get an order that stops the effectiveness of the eviction order, and so that there's a review hearing, and then maybe after the review hearing, initiate a appeal to the divisional court. And by doing that, you just have to pay $200 or so to do that. And it's easy to fill out the forms. By doing that, you stop the eviction order from taking effect, and you tie up the whole case in the divisional court. It's the higher court. It's very expensive for landlords to prosecute. You could delay an eviction if you're unscrupulous, if you're prepared to do so. You can delay it for 12 months, maybe easy. I got cases now because of COVID where tenants were not paying their rent before COVID, right? And applications were started, and then they started divisional court appeals, and then COVID hit and things slowed down. I've got people, this is in residential, okay, keep this in mind, over $100,000 owing in residential rent, right? And when you're in amounts like that, above $35,000, you're out of the jurisdiction for the landlord and tenant board. If you want any chance of recovery, and there's very little chance getting $100,000 from most residential tenants, let's be straight here. But if you want any chance, you got to bring your case to the higher courts, which is more complicated. So I think the impact of COVID has, basically empowered these professional tenants and has made it more challenging for good, hardworking landlords to recover some fees. Now, they're the minority. I don't want to scare landlords away. The investment is still sound. There's no doubt about that in my mind. But COVID has made those problems and many others worse. With respect to your particular question, and that was, what are you recommending landlords do? Should they go get professional representation to fill out the form? Should they try it themselves and maybe fail, having to start the process over? The answer really depends on the landlord client. A sophisticated institutional landlord doing a basic application, they can do that no problem. They could do that as well as I can because they have the same amount of experience. I've been at this 20 plus years. A lot of my landlords have been at this 20 plus years. Those are for the basic, straightforward, I'll call it rental arrears applications. For conduct-based applications or landlord owned use applications where the landlord wants to move in, or the purchaser who's buying the property wants to move in, you're probably well advised to get professional help for those types of applications because they're a little bit more complicated. And as you say, if you screw those up and you got to start over, that's going to put you 6 to 12 months behind. Above guideline increases, AGIs as we call them, right, where you're trying to increase the rent because of capital expenditures, you make a mistake on those documents. And if you have to start over, you may be out of time, you may lose your AGI. So the consequences are pretty big. So I would say the more complicated applications, you probably should get some help. If you're new to the game, if you're not familiar with landlord-tenant, even the basic applications, you probably will want to get some help at least now for exactly the reasons that you say, starting over and losing another 6 to 12 months of rent. It's untenable.
And I will say the majority of my questions are rhetorical to me, but they're based on conversations that I'm having in the field. Even in this last week, I fielded at least 3 or 4 calls from amazing clients of ours who are friends, and they're now professional landlords. And I want to be ultra clear that this is not a promotion of any paralegal or any lawyer or us as realtors. Like, we wrote the book on how to sell your home on your own without a realtor. Right. Is it wise for you to negotiate $1 million transaction once every 10 years when I do it 15 times a week? Whatever. Do your own outcome. But like, from heart to heart, friend to friend, there's pros that excel at what they do. Landlording, if you can get affected off one stupidity, one little mistake, and that costs you 12 months of rent, it's going to exponentially change the way you feel about landlording, because 12 months is a long, painful process. I'm not trying to fearmonger. I'm saying this happens every day to people. So when you speak to people that say, "Oh, landlording's not for me," my buddy Joe, he couldn't get somebody for 12 months. Well, I can tell you, we've never had a 12-month issue. We've had a 3-month issue. We've had a 6-month issue. In some cases, 9 months because of a back and forth. But at the end of the day, I'm not going to even say we, me, myself, and I run over 60 doors this very moment. I have hired paralegal after paralegal every single time because I'm busy. If I tell my client, no, I got it for you, what am I? Am I pretending to be a paralegal? I make one mistake and now my entire relationship of 10 years of confidence falls apart on me not dotting an I and crossing a T? No, thank you. So in this, to me, that is massive to me, where I say I'm a huge proponent of hiring the right people for the right job. In this landlording, in the age of COVID, where things have slowed down further, and are in the eyes of the court, the tenant will always be the victim, no matter, because that's how we were treated out of the gate. Landlords, don't pay your landlord, they said, out of the gate. So this is the time for our entire audience to really be very smart, think carefully at the risk and reward, like of your cost of whether it's $1,000 or $500 or $3,000. Think carefully about the stress that this can cause. And I'm sure, Doug, you'll be elaborating on a lot of these subjects.
I'm going to say, Chas, let me just time, the one thing that you say that resonates, especially with the landlord and tenant board, it's not the same with other areas, other tribunals. And I think it's a problem with the landlord and tenant board, okay? Is that if you make a mistake on the notice of termination, particularly that first document that you've got to give to the tenant, or if we're talking rental arrears, but it's really anything to say to the tenant, you're behaving badly, you're not paying rent, you owe me this much, whatever it is, you got to give that first, then you make an application to the board, then you go to the board. If you make a mistake on that notice, you could screw up the entire process and there's no going back. And particularly when you make a mistake on the notice of termination for rental arrears, if it's not a fatal mistake in the sense that the whole application is screwed up, such that you could continue, you won't be able to get an eviction order, right? With that mistake. What you might be able to get is an order for the rental arrears. But you know what? Without the eviction part of it, there's no enforcement. There's no teeth. right? That's the problem. So I agree with you on a lot. Look, whoever's listening to this, Jazz, yourself, we all do business in certain areas, right? That's where we need to focus. That's where we make our money. That's what we're good at. Okay. I have to remind myself this all the time. Like I could do my own books. But it's going to take me forever. You know what I mean? I'm going to spend 1 million hours doing it. I hire an accountant. You know, the same thing, you know, I laugh. I think about my wife with things around the house. I always say I'm going to do this and that. I never get it done. Causes me all sorts of problems at home. When I finally do, it takes me 10 times as long as it would take someone who knows what they're doing. You know, and then really what I should have done is done my business and hired someone else to do what they know how to do.
You're saying that because it's Saturday, Jazz. Saturday's the to-do list. You've already been roasted.
It gets longer and longer. I'm a big believer on focusing on your strengths and delegating your weaknesses. So, I mean, you're preaching to the choir in that sense. Douglas, you spoke about, and also Simos, about doing things right from the start. And so, we have a lot of clients right now that landlords that have found tenants. Okay, they found tenants, but let's hypothetically speaking, condo downtown Toronto, they're going to be renting out a 1-bedroom condo for like today's market. Let's off the top of my head, let's call it $1,900 a month. Pre-COVID, that was probably closer to about $2,300 a month. Okay. To protect the landlord in terms of an increase, it's frozen for 2021. Correct me if I'm wrong, but I believe it's frozen for 2021. So in 2022, we want to make sure as the landlord, they can get that market rent again of at least minimum what was the numbers in pre-COVID of 2,300. How can we write this lease agreement in place? How can we maybe put in a clause of a discount that we're giving a tenant right now? Is like, how do we protect the landlord in that situation?
So if you want to, okay, that's a good question. If you want to make your unit more attractive and lower the rent temporarily, I guess, for lack of a better word,
yes,
while preserving the advertised amount. So let's say and these aren't real numbers, you won't be able to achieve this, but you're going to use your numbers. What you really want to do is you want to say, I'm going to charge you can rent my unit now for $2,300, but you're only going to pay $1,900 in 2021. But come 2022, it's going to go back up to the market rent, $2,300, something like that. That's what you want to do. Okay.
Yeah.
It's technical and it's complicated. Put another way, in legal terms, you're trying to maintain the quote unquote lawful rent that you can require tenants to pay and that you can increase from. And there are allowable discounts in the Residential Tenancies Act, particularly in the regulations of the Act. Discounts that a landlord can use to lower the lawful rent, okay, but not affect that lawful rent. In other words, you can return to that amount essentially later, like you said. Now, the spread is not going to be $2,300 to $1,900. That's a big percentage drop. You won't be able to get there. And quite frankly, it's very technical to draft clauses like that. There, I would say you absolutely need professional help because if you don't do it right, if you give too much of a discount, you can accidentally lower the rent to the discounted amount or around there. There's a calculation that you put in place and have that lowered rent be the lawful rent forever. So you could be stuck at that $1,900 mark. So it's very, very, very important that you be very careful with how you write down the discounts. Now, one of the discounts you can use is a 2% prompt payment discount. That's where you give somebody a 2% discount for paying their rent on time or before the due date. Okay. There are a whole host of 3 or 4 other types of discounts where you're giving tenants essentially rent-free months throughout the entire year. So you can give the tenant, for example, a month rent-free spread out through, let's say, 8 months. That's an example. Okay, and there are other examples that are similar to that. Now, with the exception of the prepaid discount, prepaid prompt payment discount, you have to do all that stuff in writing. If you don't do it in writing, if you do it orally on a handshake or whatever, then you lose the protection of the act that preserves the lawful amount that makes it makes you able to go back up to the 2,300 number.
Can I combine discounts? Can I have 2-3 discounts in the same for the tenant?
Okay. You can combine some of the discounts. Again, you got to be careful. It's not carte blanche because there's 4 or 5 out there set out in the regulation, so you can't combine 6 discounts. You can combine some of them. But you got to be careful because if you go a bit offside, then you're stuck at that 1,900 number, at the lowered number. Okay. Okay. Perfect. Yeah.
And just wanted to let everybody know, because I know people are signing on a little later. Not to worry. By the end of today's brunch, we will let you know how to get in touch with Doug and Rachel, everyone on Doug's team, to answer even more questions or something personal that you might have. We'll make sure that you get connected with the team. I know, Simos, I could tell your face. I know you have a question burning in your head, brother.
A few. And it stems from, again, we manage a lot of inventory. A majority of it is downtown, and downtown is kind of where is the hot zone right now, as Bay Street's been shut down, Entertainment District's been shut down. We have a lot of one-bed vacancies, meaning like the whole support staff of the entire Toronto downtown district has been either temporarily laid off and or relocated to parents' homes, friends' homes, etc., because they're not working. So we have a lot of vacancy. We've also had the busiest month in leasing ever. So people don't know the whole truth. So I want to kind of go through a couple steps to put everything that I'm thinking into context for people to understand what truly is happening. For example, downtown Toronto, 6 or 8 months into COVID. Okay, so this is kind of like what's happening today. And what's happening today is in September, we had a 40% increase in volume year over year of leases completed. And that's on the MLS. That's on the MLS. That's registered. Forget the ones that were done privately, etc. Just on the MLS alone, a 40% increase of units changed hands with leases in the month of September. So it's never, ever been busier downtown from a rental perspective. What has also gone up at the same time is the inventory by 60%, which has never happened, not in my career or before I started 15 years ago. So there has never been this much inventory available in downtown Toronto, ever, for rent. And that is simply as a result of a record-breaking year in delivery of new apartment buildings and condominiums, the return of the Airbnb units, and of course, no foreign students and immigrants listing up units. So you have all your major arteries feeding all the rivers feeding the lake getting dammed and shut off. So there is that happening. So there is a saturation of some units, which is driving the prices to come down a bit. Now, this is where my questions come in for a professional like yourself, Doug, is when I first moved to Toronto and I was looking for an apartment in East York. It was very tight. Like I wanted to live on the subway line, of course, on Danforth. I was young. I was 20 years old, attending Ryerson University, wanted to live close to my people, my fellow Greek brethren and sistren. And it was hard to find an apartment. But if you were to go up to Leaside, there was older apartment buildings up there, and all you saw was sign a lease here and get a 32-inch TV. Sign a lease here, you get a new car, whatever the case may be. So there was incentives for me to sign a 1 or 2 year lease that were not tied to discount. Is it legal today if I were to offer a television or a material subject as an incentive to a tenant? Is that legal? Does that mess with anything at all?
From my perspective, I don't know of any law that prevents that, that sort of incentive. It's interesting that you say that because, I've been at this more than 20 years now. It's I know you guys all look at me like this young, spry, energetic, but
of course, handsome.
Handsome. Thank you. We started that way, and you're right. You were right to point that out to everyone. Thank you. I drive by the city. Like I've never, the market has been so good for landlords for so long, right? But I see these old, like get a free TV signs because it's the old style signs even,
Yes.
And I wonder if you called those buildings, would you actually get a TV or if they exist? Yeah, I don't see a reason why you couldn't offer incentives like that. Are you saying that people are doing that now? Like that would surprise me.
I think you're just asking from the perspective of if we can and our clients can, and if like we have places that we need to rent out as well, and we're wondering, could we offer a free TV or a free couch or a Simos?
No, but I'm going to go into more because I'm already doing some shit, for lack of a better word. So like I'm actually going to be asking for someone some very important questions, asking for a friend. Okay, so and it's not about the TV. So we're gonna get into it. Asking for a friend. Okay, so the TV, I was pretty sure I knew the answer. There was nothing wrong with giving anybody anything I want as an inducement. But now we're gonna get into the money. So we're gonna use simple math. I want to rent this apartment for $2,000 market rent today. Because when we say market rent, we got to be very careful. Market rent before COVID will never again be market rent. That's going to be market rent post-COVID. Right. So even if it goes back to 2000, let's be careful in the words that we use because market rent reflects the market. So today, market rent's $1,800 where market rent was 2000. Yes? Great. Mm-hmm. So that's what we're talking about. If I were to write a lease, and I'm going to say, Doug, you and your partner are coming into this to this unit. You have 2 kids, great unit. You love the unit. It's $2,000, but market rent's $1,800. Doug, this lease is going to be at $2,000 a month, and I'm going to give you. And this is where we really have to give good guidance because this is something that we're all going to use potentially, like the audience. So we need the safest way of doing this. If my unit was built before 2018, October 2018. It's imposed with rent control. There's an issue to that. So whatever that number is, we're stuck with for raising the rents. If it's post 2018, we don't have the same issue.
If it's a new build, you're saying you're exempt from the rent control laws. You're right.
That's right.
For now, yes. Until there's a new government.
100%. Yeah, 100%. And I agree.
That's what happened. That's what happened the last time, right?
That's right. They keep flip flopping. It's not an issue. I get it. So let's just call it. I want to maintain the integrity in order to get refinancing at $2,000. Right. I want to remain the integrity of the rent because I want to have that point.
Right.
If I were to give a $2,400 incentive,
right,
and I called it, I know we're going through COVID, Doug, partnering kids. I'm going to give you a $2,500 incentive as a result of COVID, and I'm going to spread it out throughout the year. So all you're paying me is $1,800. Am I bound by the 2% discount? Because I've read the Ontario lease.
Yeah, you would have a problem. So I mean, I'd have to give that some careful thought. Okay, before I just talk off the top of my head. I don't know how many people are watching this.
Okay, so Doug, let me interject. I don't want to give it that much thought.
In that example that you gave, if you did it that way, you'd get in trouble. You wouldn't be able to preserve the $2,000 amount, and you wouldn't get the refi rate. You'd have trouble with the value in your refi. So you wouldn't achieve in the way that you structured it that way what you'd want to, because you would be the discount. If you treated it like a discount, you'd be If you treated it like a discount, you would be outside of the RTA, and then you would end up unintentionally lowering the lawful rent that you want to be able to tell your mortgagee and that you're charging.
So first and foremost, I want to give a big shout out to Mr. Kevin O'Leary, who's been watching these brunches with REC since their inception in March. He personally called me out on this strategy. So I want to give credit where credit is due. Thank you, Kevin, for watching. Thank you for checking the actual paperwork. And Doug, you second his opinion. This was my client's opinion to my comments. So I just want to point that out and give him the props he deserves.
And since you're giving him a shout out, we should make sure that we're not talking which Kevin O'Leary we're speaking about.
Not the Dragon's Den, Kevin.
Not the Dragon's Den. Kevin.
That's what I thought you were talking about.
Well, no. I know, and I'm sure everyone listening thought the same.
Good call. Good call.
I want to give shout out to the real Kevin O'Leary.
Right. Yeah.
So with that being said, I just
in terms of shout outs, I see Rachel Gibbons at the bottom right of my screen. She's made an appearance.
We love you, Rachel. Thank you so much. She is her role at your place there is she heads the paralegal department, and so big shout out to Rachel. A lot of you are going to be dealing with her directly, and I can't wait to make sure that we give out the contact info and let you know how to get in touch. We have tons of questions that are lined up in the Q&A. Do want to be respectful of your time, Douglas. Simos, why don't you finish up your thought and your and kind of
so in order to accommodate this strategy. So I'm literally, so this is a real life example. I'm looking to free up $250 a month, Doug. Am I better off saying I'm going to give you a month off? What is the best?
Well, you could get away with legal discounts where you're giving rent-free periods. So you have to structure it properly, but you could do that. Yes. You're much better.
Are we able to get in touch with your office as a REC? Of course, pay for the service. Can we have a clause constructed that's within the legal confines of being able to give a $200 a month or a $300 a month discount in order to maintain the integrity of our leases?
Sure. And I'm going to... no problem. I'm also going to tell you, so I don't know how you guys are. You're using the prescribed leases because you have to. And I imagine, I know a lot of agents are attaching it as a schedule to AREA agreements or doing things like that. They're in the prescribed lease. I forget the section. There's a place for discounts. And in the, and this is also for your viewership, if they're interested, they can take a look. They still will need help. I actually don't feel it's as clear in the instructions as it can be. But in the instructions at the end of the lease, they set out all of the discounts that you're allowed to do in sort of very user-friendly language. Now, they don't give you the clause. That would have been, they honestly should have done that. That would have been great, where you just tick off the box and you fill out the amount. So I can help you with that, but they would give you and your viewership some background as to what you can do without having to go through the regulations, which are very technical.
So my commitment to the REC Insider family is by next Saturday, Tyler is going to be for sure getting out a replay of this to our entire Insider family, and we're going to make sure that clause is going to be attached to that email. So please expect it. I'm going to have Mr. Levitt's office supply us with the best possible Ontario to our viewers in the rest of Canada. Every province is different, so this goes out to the Ontario REC family. We're going to get you a clause that works within the parameters of the law and accomplishes the goal of maintaining the integrity of our leases while being competitive in the marketplace.
Before we jump into the Q&A, Doug, can you just take 2 minutes, kind of Reader's Digest version of the new Bill 184? And I'm sure a lot of people are wondering what it is and how it affects them. And then we'll take 3-4 questions if we can have your time for a little bit longer, because this is obviously a very hot topic right now.
So I'll focus on what I think is important in Bill 184. There's a few things in there more than what I'm about to tell you. One good thing in Bill 184 is an amendment to the what I call the payment plan section in that act. Landlords and tenants can now agree if a landlord brings a rental arrears application. It's an L1 application to evict because of rental arrears. A landlord and tenant can agree before the hearing on a particular payment plan and have in that payment plan a clause that says that if the tenant breaches the payment plan, doesn't make the required payments, the landlord can then go to the landlord and tenant board without having to have a whole hearing and essentially get an eviction order. Okay, you couldn't do that before Bill 184. Okay, but you can do that now. So that's a good change. So now you know if there's some money owing, and you start an eviction application because of it, you can make an agreement with your tenant and then file it with the board and get an automatic order setting out this payment plan. And if there's a breach, you can then evict much easier than you could otherwise. So that's very positive. The other thing that I'll tell you about, sort of related to this, is that if you have rental arrears that arose either wholly or in part after, say, March, I believe it's 2020, after COVID basically hit the fan, so to speak, the landlord and tenant board will look at whether you, landlord, have made efforts to work out a payment deal or to negotiate the arrears with your tenants. They're mandated to look at that. If you haven't made those efforts, then almost certainly the landlord and tenant board will not order eviction.
That's right.
And will impose a payment plan. So it's those two sections make it not only important to work things out with your tenant, but also give you a way to work it out to make evictions easier in the event the tenant doesn't pay. There's a whole bunch of new clauses that have come in that are not yet enforced. They will be. That's going to help landlords. One particular clause or provision allows landlords to recover damages, compensation. When I say damages, I mean compensation that they've incurred, damages that they've suffered as a result of their tenant substantially interfering with their reasonable enjoyment. That's new. That basically allows landlords to go and get a damage award like they would be able to at court if the tenant has done something bad and has cost the landlord money. So that's a great new thing because before that, you'd have to go to the small claims court or to some other court. Another good one is the ability to recover utilities owing. That's a big one. So landlords that have their tenants pay the utilities, where they fail to pay those utilities, you can now bring an application to the board for eviction and to recover a judgment in the amount of the outstanding utilities.
Oh, wow.
You couldn't do that before.
Mm-hmm.
You'd have to go, you might be able to get an eviction if the tenant failed to pay the utilities or breached the lease in some other respect, but you couldn't get a judgment for the amount. You'd have to go to the small claims court. And if you were inclined to do that, the small claims court would often say, I don't have the jurisdiction, even though they didn't understand that they did. And then you'd bounce around courts and nothing would happen. So that's a good change. Also, not yet.
Question for you, Doug, just on that. Is this like, I've had so many people talk about the water. They never paid the water for a year and it went to my property taxes.
Yeah,
is this the kind of bills that we're talking about?
Absolutely. I would say you could, for that, you would be able to recover it on both sections I just described because it does go to your property tax. It's like a penalty on you, and it therefore substantially interferes with your reasonable enjoyment of the complex, and you would get damages. So those two sections have been passed by the government, but they're not in force yet. They will come into force. The payment plan section I spoke about is in force. Another big and good one for landlords is the rules around Section 82. Section 82 is a clause that allows tenants to bring up any issue that they would be able to bring up in their own application in response to a landlord's rental arrears application. So it's like a counterclaim. I sue my tenant because they're not paying me rent and I want an eviction. So I take the tenant to the landlord and tenant board. The tenant could bring up what I call Section 82 issues The tenant could say, well, the plumbing is broken and the floor is this and the landlord did that and and that's why I haven't paid my landlord. In fact, not only do I not owe my landlord money, but my landlord owes me $150 million because he or she is such a bad landlord. So that's Section 82. And the changes now require tenants to give landlords advance notice of any Section 82 issue that they're going to bring. Before, you would just go to the board and you would learn at the board that the tenant has Section 82 issues. It would be ambushed, thrown upon you by, trial by ambush, we say. And it would cause delays and that sort of thing. And so now,
so is that kind of like a counter lawsuit? It's like exactly, when you sue somebody, got it.
It's exactly that. And you have now advance notice. So you know what the tenant's going to talk about, and you could bring a defense, right? That's I think, a good positive change. The last thing I'll say, because I can, go on about this, and which I think is positive, is that it used to be for landlord applications, you could only start one if your tenant was still in possession of the unit. So if you delivered a notice of termination on your tenant and your tenant left pursuant to the notice before you started your application, you couldn't go to the board to get maybe the rental arrears that were owing, or you couldn't go to the board to get damages that you were, because the tenant had left. You'd have to go to the small claims court. But now the extended the time in which landlords can bring applications. And what the Act says now is that a landlord can bring an application within the 1 year period that follows the tenant vacating the rental unit. So that's another positive thing. Those, I think, are the highlights.
And and I know you mentioned that these changes are going to be happening soon. Any idea? Are we thinking like start of 2021, or is this like, who knows when the courts are going to allow all these changes to?
So with the exception of the changes allowing, I believe I talked to you about the utilities and the damages for substantial interference. Most of these other changes are in place already.
Awesome.
Yeah.
Okay.
Yeah. So they're including the Section 82 changes. There's a form now that they give out and you have to fill out. There'll be new forms and, I'm sure a province-wide notification from the landlord and tenant board that these things are now in place. I checked this morning and they're still not yet.
Okay, awesome. So you've been bringing us a lot of value. I want to see if we can bring you some value and keep you away from that honey-do list. Are you okay for another 15 minutes for the Q&A? Okay,
sure.
Awesome.
I'll see what I can do. Yeah.
Awesome. Bobby, if you don't mind coming in, let's wrap it. How you doing, Bobby?
Doing well, gentlemen. Thanks for having me.
Bobby.
Good morning, Bobber.
With me, Bobby. Bobby, if you don't mind, let's go rapid fire at Doug. Let's bring a lot of value to our clients that are watching and listening. And Doug, I know some of these things might be, some of the answers you might have to give or might take a lot more time. Just say that. We'll let everyone know how to get connected to Doug, Rachel, and the rest of the team at the law firm. We'll make sure we get you connected. But Bobby, let's go rapid fire.
Is filing an L3 or L2 based on abandonment? The tenant is in the arrears of rent. Thanks in advance.
Okay, so that's a hard question to answer, in part because I don't fully understand it. So if the tenant is in arrears of rent, that doesn't mean that the tenant has abandoned the unit. There is an application that you can bring to the board where you think the tenant has abandoned. And in order to bring that application, the tenant actually has to be in arrears of rent. But one doesn't necessarily, the opposite doesn't necessarily hold true. So the L2 application are for conduct-based applications. L1 applications are for the rental arrears application. I would need more context to that question, but it sounds to me like there might be a rental, it's a rental arrears application. Now, if I was that landlord and I was thinking that the unit might be abandoned, in part because the rent hasn't been paid, I would serve a 24-hour notice of entry, which you can serve, right? think it's section 27 of the RTA. Make sure you pinpoint a reasonable time period in which you're going to go into the unit, right? It can only be a couple of hours or a few hours, 3 hours, like we'll attend at the unit 1 to 3 or 1 to 4. If your time period is too big, the board could find that you've illegally entered. So you got to be a little bit surgical there. And it's got to be for one of the reasons set out in the Act, which would include inspecting the unit to make sure that it is in compliance with section 20, i.e. that it's fit for habitation and in good repair. I would tell that person who asked that question to go do a unit inspection, see what's going on there. If it's barren and bare, it's abandoned, and then maybe, there's no need to bring an application. You might be able to just take over the unit given the arrears and the state of the unit.
This is making my head spin, and this is precisely why I personally can never touch these applications.
Right.
So a question like this goes off to section 20 and what?
Yeah, section. Yeah.
I hope
bring the lawyers in. That's why we bring the lawyers in, buddy.
Buddy.
Imagine how simple it is to make a mistake.
Really well is the agreement of purchase and sale. That's something that we know very, very well. But once it starts to go outside that, you bring in the service providers. Look, guys, we've been saying this for years upon years to you investors who are watching and listening as Bobby lines up and tees up the next question for our guest today. Investing in real estate is a business. Treat it as such. Look at it from the perspective of that you need an all-star team that does not only consist of a real estate lawyer that can help you close the deal, a mortgage advisor. It really pans out significantly, as you can tell, to a paralegal, someone that can handle property managers, contractors. Like, you got to treat this as a business. There's expenses in businesses. And so you need to understand that you might need to bring on a paralegal and pay the expense. As Simos mentioned earlier, this is not a promotion for Doug and his team, but we want to make sure that we continuously bring value and bring the experts to the table. Go ahead, Bobby.
From Diana and Steve, we're currently going through a nightmare with one of our tenants. She has given notice, but changed the locks on us, so we can't enter for showings. We called the police, who said they can't do anything unless there's criminal activity. They advised us to contact the LTB, but the LTB is a process which can take weeks or months. We'd like something done immediately. What are our options?
Okay, so
this is a great question.
Yeah, there's a few things you can do, and again, this is all sort of context driven. But one of the things you can do is you're entitled to change the locks. Okay, it's your unit. You just can't lock the tenants out. So you can go and you can change the locks. You got to give reasonable notice pursuant to the Act, 24-hour written notice, and you have to give the tenant the key to the new lock. Okay. But you can go ahead and you can change the locks. So that might be an option for you to consider. Now, I should backtrack and say, I don't know how many people I'm talking to. None of this is conversational. None of this should be taken as legal advice, because everything is always fact specific. And if you want to sue anybody, sue Jack. No, I'm just kidding. You got to consider the context.
No, you can sue me. All the money goes out of Simos' account anyways, Doc. So it doesn't really matter. Or sue Tyler. He's not. We can't even see him. He won't even show his face. And
Poor Tyler.
He's a new dad.
So, but I don't know if your tenant is a. He just texted us. But I don't know if the tenant is a dangerous tenant and you end up showing up there even under lawful notice to carry out that type of work, you may be putting yourself into some danger. And I don't want to push you that route. I'm just giving you a viable option potentially. The other thing that's good that you might be able to use quickly and more effectively than the landlord and tenant board, because you're right, you could bring an application to the board, but it'll take you a gazillion years and you won't be able to do the showings and all of this. Is you can go to the rental housing enforcement unit, call them up. You can't go there now because it's COVID, and why would you want But you can give them a call, and they enforce, I guess, certain provisions in the Residential Tenancies Act, particularly the provisions that deal with offenses. And if you look up online, Residential Tenancies Act, and you look at sections 233 and sections 234 and around there, you'll see a list of offenses that landlords and tenants can't do, right? And one of the things a tenant is unable to do, which is an offense, is change the lock that way. So you might be able to call up the RHEU, file a complaint. They could pursue the tenant for doing that type of behavior in provincial courts. They can charge or have the tenant charged with a provincial offense and pursue them there for a fine. But what they'll do at the outset, before it gets down that road, is they'll pick up the phone and they'll call the tenant to hear what the tenant has to say about the situation, and then to convince perhaps the tenant to comply with their obligations. And often the tenant will comply because the tenant doesn't want to be taken to provincial courts and doesn't want to be charged with an offense, and et cetera, et cetera. So the takeaways from this is RHEU, Rental Housing Enforcement Unit. You can look them up online. You'll get a number. Call them. Consider serving a notice and perhaps changing the locks. But remember, you got to give the tenant a key. But be careful if you do that. You don't want to put yourself in a situation that's unsafe, of course.
Right.
From Peter, my tenant has given 60 days notice to leave by November 1st. Still looking for a new tenant, and now one of the tenants originally would like to stay a little bit longer, 3 to 4 weeks. I suggested they pay a daily prepaid amount for 7 days rolling over.
Do it. You'll start a new tenancy. Don't do it.
What's an option for them, Doug? Just off the top of your head, just don't do it.
There's a 60-day notice that was given. How was it? An official notice? Was it an N9? Was it or was it just I'm leaving at the end of the lease, or I'm leaving in 60 days and they don't leave? If it was an unofficial, if it wasn't a proper notice, then honestly, if they don't leave as a result of this improper notice, they're your tenants anyways. You don't have to renegotiate this per diem rate. They have to pay you. If they don't leave, they have to pay you no matter what, right? So I wouldn't, if you don't want to start a new tenancy, then don't renegotiate. Don't do this per diem business. It sounds messy, and I would stay away from it.
Bobby, let's pick two questions for the sake of time. And as I mentioned, if all the other questions that we did not get to, we will make sure that we give you the contact info and talk about how to speak to Doug, Rachel, and the rest of the team.
Yeah. This one's from Mark. It says, I received an invalid N9 from a tenant signed on September 13th with October 31st as the termination date. The tenant would not pay rent for October, and we told them that last month's rent would be applied to November and that October rent was due, and that we would return last month's rent if we rented out their unit for November 1st. No suitable tenants have been found yet. They have not been served an N4, as the N4 would be their ticket out. Should we submit an L3 application before they leave on October 31st?
I'm sort of half following that. They delivered an invalid N9, I think is what he said. The N9 is a notice to terminate the tenancy. It sounds like the landlord's not prepared to accept the invalid L9 and will hold the tenant responsible for the rent that he or she owes, which is fine. You can do that. But I don't understand why you would file the L3. The L3 application is the application where you get an eviction order based on an N9 or an N11. An N9 is where the tenant gives you notice, and an N11 is where you and the tenant sign an agreement to terminate. I don't understand why you would do that. I mean, if the tenant is prepared to leave pursuant to the N9, or is going to leave and abandon the unit in any event, even though it's an improper N9, it doesn't mean the tenant still doesn't owe you the amount of rent for the balance of the term, or for the notice period for which the tenant had to give you. If that's 60 full days, right? Then it would be 60 full days. So I don't think bringing in L3 furthers your objectives if your objective is getting vacant possession, and you don't think that the tenant's going to leave on the date that he or she says. You can try the L3 and see what happens. You might have a problem because of the because you've said that it's improper.
Doug, for that particular instance, because the tenant hasn't paid for October, should an N4 be filed?
Absolutely. That's good advice. Hey, look, I'm of the view, so I'm going to go back to the beginning of this session where we talked about professional tenants. And Simeon, you said, well, I don't have anyone that's ever waited 12 months and ever, right? So the people that get stuck with the largest arrears are stuck with those arrears for two reasons. And this is 20 years of experience, and it's true in each of these. I've seen tons of these cases. One is the professional tenant knows how to game the system and knows how to appeal cases and stop evictions. And that you can only help that maybe by picking the right tenant from the outset. And if you can't do it, that's the type of thing that a good agent can do for you, because they know what's what. Okay, so that you might not be able to stop. Okay, but the other thing that increases the size of arrears is landlord complacency. Landlords, and this typically happens with small landlords that are good people, that deal on a handshake and are very friendly, and that works with most people because most people are good people, right? Most people do what they say they're going to do and pay their bills. But every so often you get a professional tenant, and when you're dealing with that person, it's important that you go as quick as possible. Now, like you said, Jas, you're running a business here. This is a business, right? If you're not going to pay McDonald's, you're not going to get your food. They're not going to feed you, right? It's the same with you, landlord. If the tenants owe you money, nothing's stopping you from working out deals with the tenants and being nice with the tenants. But at the same time, you should at least begin the legal process. This way, if the tenant turns out to be a professional tenant, which is a minority of tenants, let's be clear, most tenants and most landlords are great people. But if the minority is the person that you get, then you will be much better off if you start the process as quickly as possible. Doesn't mean you're a bad landlord, doesn't mean you're a mean person, doesn't mean you're unwilling to deal with your tenant. You're going to do all of the above, but at least once you get the process rolling, you're further ahead, and you're not going to run the risk of having 12 or 18 months worth of arrears, which will make it impossible maybe for many of the people watching to pay mortgages and operating expenses for this one unit. Like, we're not talking about a REIT here, I think, that, right? There are real people that have these investment properties that are struggling to make ends meet, even more so now than ever, right? So don't wait. And yet, Bobby, bringing the N4 is great advice. You must be a lawyer or play one on TV.
Just on TV, you're right.
I want to remind each and every person out there, with COVID now ramping into 8, 9, and we're going to be at 12 months before you know it, just like that. I think what Doug said really resonates and is very true. 99% of people are beautiful, amazing people, both landlords and tenants. I know this is an investment real estate conversation, so we're obviously heavily favored on the landlord side. But let me remind you that I have met many pieces of shit landlords that have put people through the ringer, that have provided dwellings that you wouldn't wish on your worst enemy to people, that have let people without hot water, without clean water. We've seen it all. So I think what we need to remember, first and foremost, that landlording is a business. Real estate investment is not a right. It's rather a privilege of making great decisions to get where you are and continue to make better decisions as you move forward. But never forget the absolute principle of everything, which is kindness and empathy. Because you can give an N4 is why you should give an N4, even if you have the best tenant in the world. The minute they're late, remember it's a business and give the N4. But you don't have to slap it on someone's door and say, pay me, asshole. You can very simply say, guys, this is the process of landlording. You have not been able to pay me. And I appreciate that you've lost your job, or a million different things that happen in people's lives with or without COVID. Be a human being and be a great business owner has nothing to do with anything else other than how we view ourselves and how we want to be treated. And I can assure you that when you take these steps and you act this way with professionals on your side, with kindness and empathy, even if you get that one garbage person every decade, it's okay. The market's taking care of you. Your friends and everybody around you are full of kindness and love, and you'll be fine. So I think it's easy to get down the rabbit hole with nonsense. If you go online, you're going to hear all the garbage of the world. But the truth of the matter is, real estate investing is by far the best investment you can make. Dealing with issues like this only make you stronger, and with a well-rounded perception of people's circumstances, it changes you. So as far as I'm concerned, thank you so much, Doug, for such amazing insight today, my man. I truly appreciate it. Jazzy?
No, I was just going to close off and thank Doug again for his time. Thank Rachel for making sure that this got set up. For anybody who wants to, and I saw a message come a little earlier from Tyler. If anyone wants to get in touch with Doug and Rachel and the rest of the team, just email us at info@reccanada.com. That's info@reccanada.com. We're going to spend another 2-3 minutes closing off here. Doug, to you, thank you, thank you, thank you.
Thank you all. Thank you, Rec. I'm signing off. Have a great weekend, everyone.
Take care, my man. Be well.
Take care. Again, I mean, as Simos mentioned, I mean, look, there's a lot of stuff that can go wrong. I think our mindset has always been and will continue to be that you hope for the best but plan for the worst, right? And so there's nothing wrong with building out that team right from the start, doing it properly, being proactive. So even if you have not yet invested, if you start getting educated about the process of renting out properties and so much more in the real estate investing world, that education will always mitigate risk. You'll never get rid of the risk 100%. If somebody comes to you and says this is 100% guaranteed, run away, like right away, because nothing is guaranteed. We all know that, but education will mitigate that risk. With that said, we need your help. This has been a community for a very long time, 15 years, as we mentioned, and the brunches that we've been doing now we've been putting on these brunch events for the last, I would say, 7-8 months, whenever since COVID started. So I'm going to ask for a couple of things. Please email us at info@reccanada.com with suggestions for guests and topics. As content creators, we create a lot of content, but sometimes it gets tough to keep on and continuously bringing up new ideas.
Well, and also having to guess. Tell us what you want the most.
What we learned a long time ago in our business, and peeling back the curtains, as you guys have heard me say a lot, is that it's just easier for us to reverse engineer what you're looking for. So if you tell us you want to see more Bobby Puim speak about his expertise, guess what's going to happen? You're going to see more of Bobby Puim. If you want us to speak about more RSP investing, that's something that we will bring to the table. We have a vast network. And so we want to bring all the relevant topics and guests to you. And so please email us at info@reccanada.com with guests and topic suggestions. The second thing we want to ask, moving into to 2021, we're going to start to do a lot more of these brunches. In fact, it's going to change to weekly, and right now it's every other week. And we're most likely going to be doing it on our Facebook page. And so to get the ball rolling, we want to ask you to go to our Facebook page. We know you're on Facebook because I think it's 98% of the world, or 97% of the world's population is on Facebook. And so if you have not yet connected with us on Facebook, Tyler, please, or Bobby, make sure we have the link to our direct Facebook page. You will still continuously receive notifications about when brunches are coming. Nothing's changing from that perspective, but our community is building out a lot larger and quicker than we expected. And that's thanks to you guys, because you're introducing your friends and families to these brunches. So please go to our Facebook page. Let's make sure that maybe we can pin it or something. I don't know if the platform allows that, Bobby and Tyler, but pin our Facebook page. Go to our Facebook page. It's REC Canada, and just like the page. It won't cost you anything. And again, it's another way, to stay in touch with us. Other than that, I personally, and I'll let Bobby and Simos sign off, I just personally wanted to thank you once again for you could have been anywhere in the world today, for you that are watching live on Facebook, on YouTube, and on this platform. You spent an hour and 10, 15, 20 minutes with us today, and so thank you for that.
I already said my piece, and I'll pass it to Bobby. Be kind. Use your beautiful hearts for the better. Make somebody's day brighter. It's the weekend. We have every opportunity in this beautiful city to make money. We have every opportunity to get more friends. To do better. Help somebody be better. Make your life better. Be kind. Have empathy. I love you all.
Exactly. Respect one another. Go enjoy some of this sunny, beautiful day wherever you are, and just be kind to one another. It'll get you so much farther than throwing pieces of paper at somebody.
All right. Only because I'm a little bit on the fat side. Don't say bye. Don't say bye. Let me just show something. So just so everybody knows what that is, this is the Brunch with REC. It was founded upon the principles of eating well, and my house smells like Greek cheese pie. We eat well around here.
What was that?
Cheese
Sorry,
pie.
what the heck was that? What was that?
Cheese pie. Greek cheese pie. Delicious.
Nice. It's all Greek. It's all Greek to me. I have no idea what you said, brother. Love you guys.
Love you guys.